This is Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund Fellow Richard Reinsch. Our web address is libertylawsite.org, where you can subscribe, comment, find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org. Today we are discussing with Bruce Frohnen a new book he has co-authored with the late George Carey, Constitutional Morality and the Rise of Quasi-Law. Bruce Frohnen is the Ella and Ernest Fisher Chair of Law at Ohio Northern University College of Law. He's the author of Virtue and the Promise of Conservatism, and also the editor with George Carey of Community and Tradition, Conservative Perspectives on the American Experience. He is also a senior contributor at the Imaginative Conservative. Bruce, so glad to have you on the program.
My pleasure, Richard.
Bruce, thinking about this book here, Constitutional Morality and the Rise of Quasi-Law, a question that comes to my mind in reading the book is, are we in a constitutional crisis right now? Are we presently living in one? Or are we post-constitutional now? And actually what we are doing, or I have done, is we're just adjusting to this regime of quasi-law, as you call it.
Well, I think it's an interesting and an important question, but I'm afraid the answer comes in two parts, which is to say, I believe that those who are in positions of political authority now exist in a post-constitutional era. We, the people, have not yet fully come along with that, and there remain important elements within our unwritten Constitution, our culture, our norms concerning politics, that do not partake of this post-constitutional attitude. What that does is it presents possibilities, opportunities, and risks, which is to say, my co-author on this book, George Carey, had said for decades that the Philadelphia Constitution is dead. My response had always been not quite, so I wouldn't call myself too much of an optimist. But there are elements of the old structure that remain important to Americans, that get some kinds of at least verbal support from political actors, and that give us the possibility of bringing back, if not a full American Constitution of the Philadelphia variety, something that would fit within constitutionalism, that would uphold the rule of law, and that would bear sufficient similarity to the constitutional structure that we could say, once again, that we are a constitutional republic.
Bruce, can I push you a little bit on that to add maybe some more particular observations? When you say not yet, that the Constitution of 1787 is not yet dead, what's still alive? What remains in play? What is still resisting? Well, we can talk about this later, what I think you would think of as the progressive Constitution, which perhaps has now become quasi-law.
Well, I think it's a set of attitudes. It is a minority position, for example, among lawyers, judges, and Supreme Court justices, a minority position among members of Congress, and a significant minority vision among the voters, that there is something deeply wrong, and that what is wrong has been our increasing divergence from our constitutional culture. I teach a lot of students from other countries about constitutionalism, and one of the points that I usually bring out to them is that what makes America different is that we still have at least 3 or 4 members of our Supreme Court who believe that the text of the Constitution matters. In most countries, that's really not the case. We at least have a vibrant minority culture that is committed to these institutions. How does that play out in practice? Well, occasionally we actually do strike down presidential decrees, such as President Obama's set of executive orders seeking to allow persons in this country illegally to remain. That was not upheld by the Supreme Court. So things like this still happen here. There is still outrage at the number of waivers that are being granted to people under, for example, Obamacare, allowing states to act outside the law. We still have cases such as that of Hobby Lobby, which succeeded in getting in being allowed to continue exercising the religious viewpoints of those who own the company in regard to the provision of benefits, healthcare benefits, and certain forms of contraception. So there remains within the culture an attachment to old forms. Is that enough to say that there is a vibrant constitutional culture? I'm not sure. That depends on what happens now. I think it is very true to say that we're in an era of crisis, perhaps a last clear chance of turning things around. But I do believe that what one has seen over the last few decades is a desire to stop the movement toward a regime that no longer cares about separation of powers, no longer cares about the limitations put on the government by a system of enumerated limited powers, and that no longer cares about abiding by the rule of law.
On this point, I hear in your response hints at something I wanted to discuss with you. Maybe we should just talk about it now. You say attitudes, a set of constitutional attitudes still alive out there, pressing against the quasi-law regime, we'll say, that are evident in certain parts of the legal culture, of the judiciary, certainly within think tanks and various activist networks. But I think in your book you talk about something related to this, the Unwritten Constitution, which you argue, along with your co-author, may be more important than the actual written Constitution. You also said in your answer that the text matters. The text matters to members of the federal judiciary, maybe a distinct minority now after 8 years and perhaps 12 to 16 years of progressive presidents. But nevertheless, the text matters. There is an originalism idea out there. But talk about that unwritten Constitution being perhaps the most important thing, because I think at one level, people, that sounds like a foreign concept, and yet it may be everything.
It may indeed be. And I think as an introduction to this, I'd merely point out that textualism is not about turning everyone into a mere draftsman or a follower of rules. The unwritten Constitution is an understanding, entails an understanding that the text is intended to assert formalities, to restrict the sense in which this particular governmental structure can affect our lives. The unwritten Constitution, which is the institutions, the beliefs, the practices of the people in their local associations, their families, their churches, their local geographical groups, ethnic, labor, business groups, the sets of habits about how one should approach public life, which determines the attitudes that they will take in voting, in dealing with administrators, how they will approach government, and what kind of respect they will have toward law. The unwritten Constitution of the United States was, at the time of the framing, one in which people sought in their local communities to govern themselves. It was a deeply religious set of institutions and norms, but it was, at least as fundamentally, a set of norms committed to self-government. The local town, the local church parish, or the local Calvinist church sought to govern itself within a somewhat larger self-government of the county and the state, and only deriving from that did you have the notion of a federal government which had certain limited powers, certain limited tasks. The unwritten Constitution of the United States involved all of these institutions. It was held together by a set of attitudes that emphasized ordered liberty.
On this point, on ordered liberty, you have a discussion in here, obviously, about constitutional morality, which I think would be tied to this understanding of the unwritten Constitution. And yet coming out of that, do we always have, I take it, we always have an unwritten Constitution, and we always have a constitutional morality working?
Right. They are, in one sense, inescapable because it merely goes to the character of the people. But an unwritten constitution can take many different forms. Some nations, France comes to mind, are much more centralized in their attitudes. Things center on Paris. There is much more of an idea of the nation as the fundamental unit. In the United States, that has never been fundamentally the case, although it's becoming that way. But a portion of the unwritten Constitution can be summed up as constitutional morality. This is a relatively old idea that George Carey was really very fundamental in developing. And it has to do with a felt duty on the part, especially of rulers, but also the people in who they elect, but especially of the rulers, a felt duty to live up to the formal requirements of your Constitution. And that means, in the American context, that a president should feel a duty to, yes, defend his turf in terms of not having Congress overreach its powers, not having the court overreach its powers, but also a felt duty not to overreach his own powers. And these uses of executive orders, signing statements, waivers, all kinds of, frankly, extra-constitutional decrees in order to get the results that the president wants would be considered outrageous even a couple of decades ago. There was, in effect, a constitutional morality that said the forms, especially separation of powers, but also the limits of enumerated powers, put on one a duty not to overstep the bounds, that an honorable person would not do this. And it's the breakdown of that idea, which has its roots in progressivism beginning in the late 19th century, and especially in the idea that the job of government is fundamentally to do the people's work, however that may be defined, rather than to maintain a structure of law, of limits, and of respect for the rule of law. It's that change that has made possible the breakdown in constitutionalism, and I'm afraid has had some significant bad effects on our unwritten Constitution, in the sense that an awful lot of people simply expect the government to do their will.
There is in fact, thinking about this idea, what are the limits to the federal government's power? And we really don't know, or we're unable really to articulate what those limits are. One thinks here of the Obamacare decision, of the decision upholding Obamacare with a reach by Justice John Roberts to place it under the tax power in order to rescue the program. And yet we could also say, where was the Congress in debating that and thinking about a federal government that could do this, that could in effect assign to you health care insurance? What else could they not do then? Thinking about your discussion here of the type of constitution or the forms breaking down. You have two fancy terms in here developed from the British political philosopher Michael Oakeshott, the nomocratic constitution and the telecratic constitution. You would argue the Philadelphia 1787 constitution is nomocratic, and we live under now a telecratic constitution. And in discussing that, you have a nice analysis of three giants who I think we can say have really shaped our constitutional order in many respects: Akil Amar, John Rawls, and Ronald Dworkin. How do we think about this telecratic constitution? Because I take it the forms don't matter if what really matters is the ideology and the something higher, whatever that is above the Constitution and that which we're serving in government. That's when the forms break down, I think.
I think, yes, that's absolutely true. When Oakeshott talked about a telecratic system, he commented that war is the ultimate telecratic structure. And if you'll remember, over the course of the 20th century, more and more we started hearing about the functional equivalent of war. We would have a war on crime, a war on poverty. And that is this attempt to centralize power so as to be more effective. Now, as it turns out, centralizing power does not make it more effective, but what it certainly does is it breaks down forms that are intended to limit power, to separate it and make it safer so that people can go about their lives with predictable rules that allow them to govern themselves. So George and I end up picking up on the nomocratic telecratic system in order to flesh this out toward a view of what kind of constitution one is looking at. We try to refine Oakeshott's idea. So where Oakeshott talks about a nomocratic constitution, which is focused on procedures, we talk about a mediating constitution, which is to say it assumes that a society is a group of groups, that we all belong to a variety of associations, and that the national government is merely one of these associations, whose job it is to maintain peace, order among these groups so that they can do their own jobs. And this is where people actually live. Well, the thing about that kind of mediating constitution is that it accepts society largely as it is. There may be changes, but they're going to be up to people acting in their non-political capacities as well as through the legislature. If one feels that society is unjust, that society has broken down and is fundamentally wrong, and one wants to transform this society, the model one will take will not be the Constitution of 1787. The constitutional model will be that of the French Revolution, which was a commanding constitution, which sought to transform society through political means, concentrating power at the center. This kind of constitution will not abide by limits like enumerated powers. It will not abide by forms like the separation of powers. It will instead seek to make its ideological principle real.
Yeah. Thinking about making the ideological principle real, we hear a lot about just the idea of equality, of social justice, and government serving those ends. And in a way, you overlay this foreign ideological unwritten constitution onto the written one. And it seems, but the written one is separation of powers, is Congress is supposed to be the first mover or the first among equals. You overlay that on top of it, it seems to produce all manner of distortions. I mean, not just the typical things we see when government takes on more than it can handle, but there's something about the Madisonian Constitution interacting with the progressive Constitution, the nomocratic with the telecratic, that is incredibly warped. And we really do get sort of this administrative state that has strange, we want to check it, we try to check it in strange ways, and yet that seems to drive it all the more.
Right, and it creates a great deal of confusion. Europeans laugh at American administrative procedures because they really don't make sense. Europeans are much better at setting up a monarchical bureaucratic structure because they've bought into it completely. We, on the other hand, understand, and the American people understand, the need for power to be checked, balanced, and separated. You often hear people it's a sign of how our unwritten Constitution hasn't been completely lost, that you often hear people claiming, I'm voting for one party for president and a different party for Congress because I believe in checking and balancing powers. Now, that's not exactly what the framers had in mind, but it shows this desire to check power. And so it plays out in certain odd, I don't mean to get too technical, but certain odd ways. For example, for a significant period of time, Congress tried to, when it would hand over all kinds of power to executive agencies, it tried to keep some of it by having what was called a legislative veto, which said, in essence, all right, we'll give you the power to do this, to decide, for example, who gets to stay and who will be deported. But if one house of Congress disagrees with you, then we can take that power back in this instance. We can legislatively veto our own legislation. And there was a lot of Sturm und Drang when the Supreme Court eventually decided, that really doesn't fit with separation of powers. It doesn't work. It's unconstitutional. So officially, we no longer have it. And yet legislative vetoes are written into dozens and scores of pieces of legislation. And it still survives in all kinds of bureaucratic agencies in their rules of proper procedures. We allow Congress to still do this sort of under the radar.
Yeah. Well,
So the mixing of powers continues.
Think about this idea of the separation of nomocratic versus telecratic constitution. Something you said about group of groups. We're all a part of different groups, and the nomocratic constitution will accept that you will govern yourself within these different spheres. I take it then you have a pretty deep anthropology, you and your co-author, in thinking about the type of constitutionalism that you say is evident in the founding, and which would make better sense of an ordered of society of ordered liberty.
Well, I think so.
A relational. I guess I'm thinking of a relational personhood versus this sort of autonomous individualism, and also the way the individualism seems to work very nicely with sort of a very collectivist government doing big things for us.
Sure. I mean, if you want to see that particular vision, it is, of course, Tocqueville's vision of how things will go wrong in a democracy. And it is the exact vision that underlays Rawls's view of what a good constitution will look like. We're all sort of abstract individuals behind a veil of ignorance. We assume that we will be the worst off in this new society. So as abstract individuals who have no connections with anyone else, we will end up choosing a regime that will take care of us. So hyper-individualism leads to an incredible concentration of power in the center. Whereas the tradition that brought about the American Constitution much more relies on a robust view of the human person as somebody who engages in different relationships with different persons and different groups, many of them at the same time throughout his or her life. This person doesn't exist as an abstract monad. We belong to a variety of groups. We express our freedom, our individuality by choosing which groups to belong to. We have this right of exit and this right of entrance. So it's not as if we're not full human beings. In fact, the argument is that what makes us full human beings is our ability to partake of sometimes very tight-knit cultural groups and sometimes much more loosely knit groups, and to be able to fully participate in more than one of these at a time, and to choose which ones we leave, whether happily or with regret. And that's what makes for a full human life. Living out our lives in politics as individuals who cast a vote every few years, which when you think about it is a very abstract act. I'm choosing this person who I think will support this list of programs. Yeah. That is a very impoverished view of who the person is. There's a very impoverished view of what society works like.
Yeah. We're thinking here also, I mean, there's coming out of these two constitutions, the telecratic constitution, you say, if the constitution is subsumed under something higher like equality or individualism, or both, then necessarily justice involves the government remaking that society. And if that is true, then you actually do need, you would de-emphasize, it seems to me, Congress, you would de-emphasize that sort of give and take transactional politics, not entirely, but much more important would be the presidency or the judiciary working together.
Right, certainly. And the other thing that grows out of this, of course, is that justice ends up being de-emphasized in what I think normal people would think of as its normal conception, which is to say the person facing the power of the state no longer really matters nearly as much as under a more traditional conception. Because what really matters isn't vindicating the reasonable expectations of the people who are in front of you, right? Deciding, did you as a person have a right to expect that, for example, you could run that red light because you're answering an emergency? Or did you have a right to expect that you could shoot that person when they were coming onto your property? Right? The usual understanding of justice has to do with deciding what is reasonable to believe you have a right to expect. This ends up going by the boards if you've got a grand project that you're involved in. because you have to decide how this will impact our drive for equality or our drive for individuality. So what you end up in the United States is a legal system that it's increasingly becoming an affront to due process. We no longer go to court. More than 9/10 of the cases now are settled before they ever get to go to court because everything is now plea bargaining. And when you think about it, bargaining has very little to do with justice or law. It's bargaining. You determine how good a lawyer you've got, how much the prosecutors want to convict you, how many assets they're going to use in coming after you. It's no longer a process that's concerned really with justice. It's concerned with policy. And that undermines the very nature of a people. It makes us no longer a self-governing people under the law. We become bargainers with a very powerful state trying to maintain some kind of autonomy.
Yeah, I think here as well in the field of torts, a lot of examples we could appeal to. Something that I remember is the idea of market share determining how much you owe a potential victim.
Exactly.
And the ways
right.
in which that brings people settling and bargaining to the table, as opposed to the tremendous cost of lawsuits. And then, of course, the class action system itself, which is in many respects hinges on the idea, I think, philosophically, that you owe certain things as a result of how you've made a lot of money. These people have been slightly injured by what you've done, and why not make it up to them? Of course, the money always seems to go to the trial lawyers, or by design almost. Question here on thinking about the rise of the presidency here in this system. So I was thinking de-emphasizing congressional elections and emphasizing or making the presidency the center. I mean, this is really, think about our unwritten Constitution, the way we speak about down-ballot elections, off-year elections, and everything centers on the presidential election. You can even feel it the way the press covers these now 2-year-long campaigns for the presidency that seem to start the summer after the most recent presidential election. A lot of that is because of campaign finance rules, obviously. But thinking about the centerpiece of that, and also obviously what's hanging out there right now, which is the presidency seems so important that people are willing to do all manner of things to get their person elected because they think their liberties might be at stake in a very real sense.
Mm-hmm. That's right. I mean, George and I refer to Congress in the book as the great enabler. Yeah. Because for their own reasons, members of Congress decided that it was better to go ahead and delegate huge amounts of discretionary power to bureaucratic agencies to set the rules, so that members of Congress could claim credit for, creating workplace safety, because we'll have the Occupational Safety and Health Administration, whose job will be to, create workplace safety. And they'll work out the details. And, of course, what that means, despite the fact that we've got laws on the books that say that these rulemaking procedures have to follow certain, procedures, in the end, what's going on is executive action. So the president really does become the center of the government, which is very much not what the framers expected or wanted, and is very difficult to control, particularly in a law-like fashion. When you've got these detailed regulations being decided within these units of the bureaucracy, it's easy to say, we'll all just sort of bargain it out. And that's what a lot of lawyers and political scientists assume is going on. We're just having some good faith bargaining. There's lots of procedures for people to have input, and what comes out of it will be relatively decent and kind of like law. But of course, what we find, especially over the last few years, is that an ideologically driven president can cause this bureaucratic structure to fall in line and serve specific ends above and even against the law. So, for example, you have the Department of Education, which is using its power to sue, embarrass, and otherwise harry colleges, universities, and even high schools to force changes in policies that have no basis whatsoever in law. Under Title IX, you have mere dear colleague letters, that is, the beliefs of mid-level bureaucrats at the Department of Education dictating very specific policies in our educational institutions that go against the clear language of the statute that they're supposed to be enforcing. This, of course, takes place in areas that most of us would rather not even talk about, transgender persons in bathrooms, but also in very important areas that go to due process rights, talking about sexual assault, which is, of course, a very serious issue. But changing the burden of proof to put it on the accused, eliminating
preponderance of the
procedural
evidence,
safeguards.
right? Preponderance of the evidence is the standard of guilt it was lowered to.
Yeah. But within the universities, they're allowing them, in essence, to switch the burden of proof before they're expelled. So yes, both those are going on, and reducing procedural protections. This is very serious business that goes to the essence of our legal structure and our legal culture. And to be doing that on the basis of a generalized ideological view at the top that's being carried out by a relatively few ideologues in relatively low positions on the basis of no law whatsoever should be quite frightening to pretty much everyone.
On this question, so this would be a prime example of quasi-law, of ruling through a Dear Colleague letter. Every college and university in the country that receives federal aid has now, when it comes to sexual assault cases, to do X, Y, and Z, and in effect not protect their students according to standard norms of criminal law and procedure as we've practiced it in America. This is an incredible thing. The Office for Civil Rights, I am told, has governed through Dear Colleague letters for years. It's only now that it's because liberty is at threat, a very real sense of personal liberty is at threat, that it's beginning to take notice. And we see the 26 states, was it 25 or 26 states appealing the transgender bathroom letter, which recently they got an injunction against it, temporary. So there is, I guess that would be coming back to this idea of what remains in play, what remains competitive. There's an example there. Thinking about this presidential situation, though, during the Reagan administration, no less than the late Justice Anton Scalia argued for using the regulatory state to Reagan's benefit. Congress was Democratic, and these were institutions that you could control. We also have Republican presidents being pretty, aggressive with the use of power in foreign policy outside of constitutional strictures. It seems like now it's come home. It's come home to roost, so to speak, and we have a progressive president using this for domestic policy in an array of areas that has been almost unprecedented.
Yeah, I think that's exactly right. If we present this as a Democratic plot, we'll be doing a disservice to the truth, but also a disservice to those of whatever party who want to reestablish a more fundamental commitment to the rule of law. The roots of this problem go quite a ways back, close to 150 years, really to Woodrow Wilson's idea that the purpose of any administration is simply to do the will of the people, as expressed in a few votes.
Yeah.
And to do that as effectively and as efficiently as possible, which meant through a centralized, hierarchical, bureaucratic structure that would not be answerable to the people. The problem lies there. Now, it's developed in a number of ways. Obviously, the New Deal played a very large role in this, but Nixon overreached in trying to impound monies. George W. Bush used signing statements in a manner that clearly went beyond his constitutional powers. And the real problem is an attitude toward government, and no party, no particular individual is immune to the effects that this has had on our constitutional morality. We no longer recognize the importance of these formalities in and of themselves. Yeah. Sometimes they mean that we cannot do what we want to do. And this goes especially with the enumeration of powers, but also when everyone, and certainly I bring it up a lot, when I talk about the delegation of powers, Congress's decision to hand over these vast areas of regulation to bureaucratic agencies, I tend to be laughed at by various other academics. Oh, that's water under the bridge. It's gone too far. What are you going to do? Make most of the government unconstitutional? Well, it's not so crazy an idea to say that we should be doing less in a more law-like fashion. It would, for example, be possible for Congress to do not all of what it's doing now, but a significant number of things administratively Congress could do if it would simply require that its own committees write the laws.
Yes.
And that it pass on them directly instead of handing over this right to bureaucratic agencies. Then you'd have a larger set of people working for congressional committees, and you'd have much smaller executive agencies that would be principally responsible for enforcing the rules. Now, enumeration of powers means a lot more of this would have to go back to the states, which, again, I fail to recognize as being the end of the world. Mm-hmm. That you might have a different welfare system in Maine from what you would have in Texas. In point of fact, we have different systems in both of them anyways. It would be a matter of degree. But I think the real thing is we've lost our respect for the power and the importance of forms, that they, in fact, protect us. Right? There's an old book which was turned into a movie, A Man for All Seasons, in which Thomas More, who ends up being a great martyr to the truth, asks a supporter why he would go after someone he thinks is wrong. Well, because he's evil, I must go after him. But there's no law that says we can. You must go after him because he's wrong, because he's evil. And the point Moore keeps coming back to is, so you would cut down all of the laws in order to get at the devil. Then what do you do when the devil turns on you and there's no laws for you to hide behind?
Yeah.
And that's the position we find ourselves in now.
Very well put. Thinking here about Congress, James Buckley had a book. He came on this program, Saving Congress from Itself. Something interesting here is the way Congress interacts with the executive branch. It's already outmatched. Reams of lawyers, PhDs, economists tucked away in executive agencies, good salaries, and churning out various supports for executive, for regulatory rules, laws, and Congress really finds itself unable to compete with that, and yet Congress rules in the most minute ways and the most discreet of ways throughout the country, and this is why it talks about been a huge increase in the size of state government bureaucrats. There's a huge use of actually private sector institutions to administer federal government rules, and so the question would be Congress being held to the actual standards of Article 1 and ruling in the light of national objectives in general ways for the good of the republic conceived within that realm, as opposed to trying to attempt to do all manner of things and as you talk about delegating power in this regard. I think the question is, the federal government, no one believes in our institutions at all. And the only one is the Army. The armed forces are still have like 60+% approval, but no other institution in our government does. And you have to conclude, particularly with Congress, when your public approval rating is somewhere between, Kim Kardashian and the LA Raiders, I don't know. You're doing something wrong, and yet they conclude, I think, that they're better served by being power brokers to the executive branch on behalf of various clients and interests, rather than being a self-governing body.
Right, because particular members of Congress keep getting reelected.
Yeah.
So it works for them as individuals, even though it doesn't work for the institution, which again is a violation of the ideal of constitutional morality. You owe it to your institution as well as your nation to stand up for what that institution is supposed to do. And this really, I liked your point about the creation of these large bureaucracies at the state level. When I was working in the Senate, one of the things we kept trying to fight over were what were called federal mandates. Again, it's the federal government, the Congress simply says to states, oh, you have to do X, Y, and Z, whether it's putting up the ramps so that people in wheelchairs can get to the doors, or it's something very specific about protection of documents. Well, they simply think that they can wave a magic wand and the state will do it. Well, there's all kinds of reporting requirements that go along with this. So a significant part of our bureaucracy is actually directly tied to Congress's desire to rule without taking responsibility for its actions.
Yeah. One question I have for you. The Nomocratic Constitution appears weak, philosophically, in the face of social justice, in the face of I'm an unencumbered individual, and that's how society should restructure and has been restructured to support those ideas. The weakness of the Nomocratic Constitution would be, in your opinion, is it the precariousness of mediating institutions in a democratic society and those losing luster and appeal to people in the face of, take away big decisions for me, government in various ways, give me some running around money, let me, pursue my happiness in various ways, whatever that might be. No one can judge and all that sort of business. It seems to me that's sort of the allure of what we're in now. That's what Obama really understood as he came into office. And also the ways in which even these mediating institutions themselves can become the tools of government, right? The corporations willingly sign on to Obamacare because they think the government is going to guarantee them clients and revenue. Boy, that hasn't worked out. So I guess, I guess I'm just thinking about that. What's this sort of, the sort of weakness of the classical liberal document?
Well, I think you're right. And the way I would phrase what I think you're saying here is that it requires difficult Republican virtues.
Yeah.
Whereas today's Constitution requires rather easy virtue signaling, right? You can cast a vote, and that means you're a good person. I recycle, so it's okay that I don't take care of my own neighborhood. I don't take care of my own children. I let the state take care of them. But it's okay because I voted for it. So I want a system in which this is possible. You get to abstract your virtue onto the system. A free Republican government, and I would argue a decent life, to be perfectly honest with you, requires that we take responsibility for our own virtues and vices. We recognize that we live our lives in a variety of relationships, and it's up to us to make those relationships good. You can't simply abstract your ideas and act with a few political choices and claim that you're a virtuous person.
So in this respect, though, it seems, if we're thinking about, so you're sort of emphasizing we can't remove ourselves from a certain communitarian ethos,
right,
and have a free self-governing republic. That's hard, and I guess I keep thinking that's hard because of other people, or other people, but also I guess the way in which we think about happiness and what the pursuit of happiness is now. I mean, our unwritten Constitution has been very much reoriented, and not ours. Most modern democracies, particularly in the West, have sort of reoriented around these ways that Ronald Dworkin discusses, or Akhil Amar, in the sense of the allure of my, I have the right to define existence however I see fit, to paraphrase Justice Kennedy in the famous mystery passage. That has a powerful hold on people.
Yeah. Well, it's interesting that you bring that up because George, my co-author, and I, we had very different views on this because one of us is a religious believer and the other is not. And so the question comes about, is this just because of secularization and modernity, we no longer look to a pattern of life that we should conform ourselves to? But it's interesting, despite our very different views on specific religious issues, what we both really did agree on was to have a coherent view of politics, you have to at least think about and recognize that there is a kind of pattern to our existence, that certain things are, in fact, conducive to human flourishing, and that one of those things is, in fact, virtue. Developing your own character in a way that recognizes the dignity of those around you, that recognizes your duties, most especially to those you're closest to in this world. That if you don't have that, you're not going to be living a good life. And the real irony, of course, is that the more we centralize power, the further divorced we become from our duties to one another. So where during the era in which the Constitution was framed, there was a kind of a virtuous cycle, which is to say that One was brought up in these local institutions which taught us specific habits, the need to have affection with those around us and their respect, and therefore we valued honor, and this led to a commitment to self-government and maintaining only a small government at the more distant level. So long as we recognize this as a decent life, the smaller government maintaining the local institutions created the basis for its own continuation, right? Attachment of the people and attachment to a certain kind of virtuous life. But the more you buy into the idea that the state needs to correct X, Y, and Z, the state needs to make things better for us, the more you lose connection with those institutions that teach you how to be relatively happy in community. And the more you seek happiness in purely individual pursuits and in abstractions, virtue signaling. So it becomes a vicious cycle where you more and more centralize power and more separate yourself from everyone around you. So, yeah, it can look like, well, this is inevitable and we've now got this other system going on. There's no turning back. The problem is, of course, that this second model of centralizing power, as we've seen in country after country in the developing world, bankrupts society.
It's consuming, I don't know if you would agree with this, I think it's consuming social capital,
right,
moral capital that it can't replace.
And literal capital.
And literal capital, that's right.
It's consuming all of them because we no longer have the motivation to act honestly, keep our contracts, to act honorably, not sue one another unless we actually have to take care of our families. We end up putting more and more on the state, and the state can't afford this. You see this even in Europe, where standards of living are going down. If you look even in the United States, it's clear over the last 8 years, particularly the middle class, but people in general, other than at the very top, and that's the irony of socialism, that those who are at the top have sufficient power to keep getting more money. But everyone else is seeing their standard of living go down because we cannot afford to live this way.
Yeah. No, very, very well put. Bruce Frohnen, thank you so much for coming and joining us today. We've been discussing your book, co-authored with the great George Carey, Constitutional Morality and the Rise of Quasi-Law. Thank you so much.
Thank you, Richard.
This is your host, Richard Greinch, and you have been listening to a podcast that can be found at libertylawsite.org, where you can subscribe, comment, and find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org.